Right, I think I've been given the go ahead. We can start. This is a slightly awkward Zoom start to a talk, but good morning everyone, and welcome to the next of the junior breakfast briefings. This morning you've got Esther and myself talking to you about planning inquiries, the basics. And just for any of you who maybe haven't attended one of these before, this is part of our junior breakfast briefing series. And we really want to emphasize that the whole idea behind this series is that we are really setting out the basics of sort of a number of different topics in the planning world, really very much designed for those at the early stages of their career, and almost a safe space for people to also be able to ask questions about those basic points that maybe you feel that you should know, but let's be honest, if you haven't come across certain matters in your practice, you might not know. So it's very much starting at that level. And I think before we crack on, I'm going to do a plug just right at the start to let you know that we have a number of other junior breakfast briefings it's already been scheduled. The next one we have is on the 17th of February, and that's on habitats. And I think you've got Horatio and Connor with you on that. And then I think we've got another one on schedule for the 3rd of March, which is on injunctions and committals. And I think Michael Fry is going to be talking to you about that. He's obviously just been involved in quite a headline-hitting matter involving HS2. So definitely tune into those in due course. And I think also I'm just going to set out that we are going to circulate these slides, so please don't feel you have to take any notes. We've also included in them some hyperlinks to various resources, and I think even a YouTube video. So hopefully you'll get that in due course. And we're also going to, I think there's a chat function is available on this. So please do send us through your questions, and to the extent we can, in the time we've got, we will try and either address them as we go or pick them up at the end. So please do send them through. Otherwise, I think I'm going to hand over to Esther. Oh, before I do, we're going to briefly introduce ourselves as well. So I'll start on that, just to say that I'm 4 years into practice. My practice is a broad-based practice in planning and environmental law. Been doing quite a bit of work recently on climate change litigation, but in terms of inquiries, I've had my fair share of experience of that. In fact, my first year of practice, I had a sort of weird and wonderful intro into inquiries by being involved in some very long-running Transport and Works Act inquiries in relation to large proposals by Network Rail to downgrade and close a number of level crossings around East Anglia, and some of those went on for sort of 6 or 10 weeks long inquiries. So that was a sort of bit of a baptism of fire, that was. And I've also been involved more recently representing councils at Section 78 inquiries, and have had one recently just last month in the sort of remote inquiry setting. So hopefully, I think Esther's had quite a bit of experience in the remote inquiry setting, so we can hopefully talk to you a bit about that as well. But without further ado, I'm going to hand over to Esther, who hopefully can introduce herself and then take the reins on the next slide.
Thanks very much, Merrow, and good morning, everyone. It's great that you can join us this morning. So just to introduce myself, I'm a bit more junior than Merrow. I've been practicing in chambers for about 1.5 years, but I've been lucky enough to have a lot of inquiry experience in that time. I had two inquiries during my pupillage, and that's kind of carried on from there. Various types of inquiries, enforcement, planning inquiries, some called in by the Secretary of State, some just standard decided by inspectors. So hopefully I can give you some of my experience from those inquiries, including, as Mary mentioned, most recently, a 2-week remote inquiry concerning planning permission for a school in Hampstead. So I'll hopefully be able to give you lots of hints and tips about the inquiry experience. So if we go to the first slide, thanks, Merrow, just what we're going to run through with you this morning. So first of all, I'm going to deal with when and why a planning inquiry might arise. Merrow is going to talk about the key stages in the lead up to an inquiry, including statements of common ground, conditions and Section 106 agreements. I'm going to then deal with procedure at the inquiry and roundtable sessions, which are a relatively new beast in the last few years, as well as tips for giving evidence. Now, I think from our list of attendees, many of you will be working at law firms, but and you might not end up giving evidence at an inquiry, but these are all things that you can pass on to your clients and kind of discuss as sort of team tactics when you're thinking about how to prepare for the inquiry. Merrow is then going to deal with costs. And finally, we're both going to talk about attending inquiries using video conferencing software. Now, as we said, we both have quite a lot of practical experience of inquiries. So we're going to adopt a little bit of a tag team approach here and jump in with comments where we think that might be helpful. So next slide, please, Merrow. So lots of text here, but just really an overview of when an inquiry might arise and the kinds of appeal that exist in the planning world. Just to note, Mary mentioned Transport and Works Act orders, and she's got a lot of experience in the highways and footpath sector. They're not mentioned on here, but they're obviously a type of inquiry that exists, and they have their own procedural kind of aspects, which either we'll talk to today, or that's something for a future presentation. So the main type of planning inquiry, Section 78 appeal, where planning permission has been refused, there is an opportunity to challenge that, and those challenges will sometimes be heard by inquiry. And similarly, in the case of non-determination, where a local planning authority fails to determine an application of planning permission within the requisite time, that can also be appealed. Essentially, the appeals arise where the local planning authority has made a decision not to grant some kind of permission, consent, or certificate, or they've issued an enforcement notice. There is a statutory right to challenge that for the applicant, and in those situations, an inquiry might arise. So if we could go to the next slide, please. But inquiries are actually not very frequent. So around 2% of all appeals are determined by planning inquiry. Most of them will be determined by written representations, by far the major part, and others will be determined by hearing. The procedural guidance, which you'll be hearing more of from Merrow, produced by PINS, sets out the criteria that the inspectorate will apply when they're determining which procedure to use. And I've just summarised that here on this slide. So if we start with inquiries for a planning inquiry, so where there's been a refusal of planning permission and that's being appealed, an inquiry will only be adopted where the evidence needs to be tested by an advocate, there are particularly complex issues, or the appeal generates substantial local interest. So local people will want to come along and potentially participate, make representations. A hearing is more appropriate where PINS considers the inspector is able to test the evidence, the status or personal circumstances of the appellant, the applicant are at issue. There is some local interest, so people might want to come along and watch, or the parties can present, it's considered that the parties can present their case without an advocate. And finally, written representations will be used where the issues can be understood from documents and a site visit, or the issues are not complex and evidence doesn't need to be tested. So usually the appellant will indicate in their appeal documents which procedure they think is most appropriate. And actually it can be quite a tactical approach, whether you're going to go for an inquiry or a hearing, if it's complex enough to justify that kind of procedure. Generally, local planning authorities tend to do better, and this is just on the figures, at the sort of round table and the hearing sessions. So if you're acting for an appellant, my advice would be to push for an inquiry, because the results tend to show that you're likely to be more successful using that procedure. So next slide, please, Merrow, and I think it's over to you. Unless there's anything you wanted to add on those first two slides.
No, that's great. And yep, it's over to me. And I'm going to talk you through now the sort of stages in the run-up to a planning inquiry, because actually there's quite a bit that gets done in the run-up to the inquiry before you even get to the inquiry itself. And there's a lot of different deadlines. And I think particularly when you're starting out, it can be a little bit confusing. I'll speak for myself, but to keep a abreast of all the different stages and things you need to get done. So we're going to run you through this just to sort of caveat it. This is the general stages for a sort of bog standard Section 78 appeal that Esther was mentioning. There are slightly different procedures and certainly some different timelines for other potential inquiries. And just as examples, this isn't going to cover recovered appeals where the Secretary of State's called the matter in for his or her own determination. Also, and this is really a flag, where you have an enforcement notice that's essentially been served in relation to the same planning matter, then you've got to be aware that there are, generally speaking, shorter timelines to make your appeal. So the enforcement, you could have a situation where the enforcement notice is served before your planning application for essentially the same development has been determined, or you could have a situation where your enforcement notice is served after your planning application is determined. But in both cases, there's different timelines, and generally they're shorter. So I'm just putting a real flag there. I'm not going to go through any more detail, but I put the relevant part of the guide there, so just be aware. And also then there are matters where I think this is really where the planning inspectorate PINs have on their own accord determined that actually this appeal should be going to an inquiry, and sometimes that can happen later on when things become clear that it's more complex than people thought. I've actually got an inquiry next week that was, I think, due to be a hearing up until December when it got switched. So just to caveat what I'm saying, we're dealing with the bog standard Section 78. And if you, this is the absolute top tip from certainly my side of the presentation. If you take away nothing else from this presentation, please take away this. There is very detailed guidance from the planning inspectorate in relation to inquiries. Now we've included a link on planning inquiries. We've also included a link on enforcement, but there, I should just note, there are others. Esther mentioned about rights of way inquiries, and I know from my own experience that there's similarly detailed guidance on how to handle those kinds of applications. So we're obviously going through the basics, but please note that more details are there, and really that's your key, that's your ticket to finding out all you need to know about these topics. But moving on to the sort of key stages, first stage obviously is the appeal needs to be submitted. Usually it's the deadline for that is 6 months from the date of the local planning authority's refusal notice, essentially. Or if it's non-determination, as Esther mentioned, it could be a non-determination case, then it's 6 months from the date on which the decision really was due to be decided. I say usually because obviously I've flagged there are some other cases like the enforcement context where it may be shorter. I think this is a bit cheeky that actually the guide, certainly the guidance is that if you want to have, as the appellant, if you want to have the matter dealt with as an inquiry, you're supposed to give 10 days notice prior to submitting your appeal to the council and to PINs. So it seems it's a bit cheeky because it's 6 months, sort of less 10 days, but I think that's only guidance, but just to be aware of that. When you submit your appeal, the appellant should be covering the documents that I've set out in the slide. The one I'd highlight is obviously that you're supposed to be submitting your full statement of case, so really your full case on why the appeal should succeed. And so the guidance emphasises you should really wait until you finalise that case before submitting it. Don't submit it on day one after the decision notice and then follow up with lots of other documents in month 5. So that's what I would emphasise on at this stage. The next step is that the appeal is obviously received. It has to be validated. Generally, that's pretty procedural, but do note things can crop up at that point. I've had a case where I was advising on a matter where PINs were questioning validation because the name of it was company really, but the name of the individual concerned was different in the application to the one that was specified in the appeal. So there was a question raised because they're supposed to be the same party as to whether that was proper. That got validated, but just to note, things can crop up at this stage, but generally it's pretty procedural. Once the appeal is validated, PINs then sets the start date, and that is your key date, because from that flow all the, generally speaking, most of the other deadlines. And you can see there that expect that the inquiry will happen about 3 to 4 months after your start date. And what you get is you get a letter from PIMS saying this is your start date and then setting all the other deadlines. So they should obviously tell you that in detail. The next step is 1 week from the start date, the local planning authority needs to send in a questionnaire and essentially specifying what they think the right procedure is. If they are saying an inquiry, they should give details about the number of witnesses, how long they think the inquiry will take, whether they expect to be represented as well. And also this is the stage at which the local planning authority should be notifying essentially the public and interested parties about the appeal, about the fact that they can make representations and how they do that. So that's sort of in the hands of the local planning authority at this point. And then we get to 5 weeks, so a month later from that step, you then have the deadline for the local planning authority submitting its full statement of case. Also, this is the deadline for interested parties sending any further representations they may want to. The guidance emphasises that they can rely on what they've already said in relation to the underlying planning application, but if they want to put in more because now they've seen the appellant's statement of case, this is the time for them to do so. And I've also noted here that if you're sort of registered as a Rule 6 party, and it's Rule 6 because this is all set out in Rule 6 to the procedure rules, essentially it's when you've got an interested party being recognised as having the sort of formal involvement in the inquiry procedure, then they may be required to submit a formal statement of case as well. So just to note that. But it's also the deadline when it's intended that you should have your agreed statement of common ground between the local planning authority and the appellant. So just on the statement of common ground, these can be very useful. Sometimes I refer to them as statements of uncommon ground because they are not just about setting out matters of agreement, but also the key matters of disagreement. That can be useful too. Do note again that there is guidance on this and a pro forma online, which we've got the link to. And I think now the guidance is suggesting, certainly I've seen this in my most recent inquiry, that the statement of common ground, essentially you have a table format where you have matters of agreement, matters of disagreement, and then you set out in a table what the appellant's position is, very briefly, and what the local planning authority's position is, and that does seem to work pretty well. But also in the guidance and pro forma, it sets out sort of some of the key points that the statement should cover, such like what are the relevant policies, planning policies, what are the most important policies for determining the application, and do note that that is quite important now in terms of the new the paragraph 11 tilted balance test in the MPPF, but I'm sort of segueing here. But they so matters of policy and what's relevant, it may cover whether there's agreement on whether policies are out of date. It also is a chance for any agreed conditions to be set out. Now, I think Esther may touch on this in the inquiry, but when it comes to conditions throughout the inquiry process, it's sort of I sort of refer to it as a without prejudice basis, in that obviously the local planning authority doesn't want the appeal to succeed, but they will look to agree the conditions that should be imposed if it does succeed. So this is where the first step in which they should really be doing that. And also the statement of common ground is where you can set out agreed sort of core documents, and the core documents element of inquiries is really useful actually. Where the parties will agree, okay, these are the key documents, planning policies, whatnot, so that you don't have repetition between the parties submitting the same things over and over again. You set out all the application documents and the statements of case, and they're all sort of numbered, so everyone knows how to refer to them. And this is really the point at which you should be trying to agree that. I think generally the actual documents are, if they're going to be sent out, I think that's at the proofs of evidence stage, which I'll come to, but someone can correct me if I'm wrong on that. But that's the statement of common ground, which, as I say, can be useful. It depends on the case, can be less useful. Then you get to the, and I should also add, you can have separate statements of common ground. So you can have a planning statement, and then you may think in a particular case, particularly where you've got more complicated matters, it may be useful to have a separate, let's say, highway statement of common ground, or a separate education, I'm making this up, but so you can divide them up as well. Then you get to your case management conference, which is 7 weeks from the start date. Generally, this is a sort of teleconference on the phone, and I've found that that's remained the case even in the remote world. If it's a particularly big inquiry, you would have a pre-inquiry meeting. Now, normal pre-COVID times, that would be in person, but as I understand, that's happening remotely now. But this is really, it's again, I think it's a useful stage. It's really a chance for the inspector to canvass and deal with procedural issues about how the inquiry is going to be run. As I've noted here, normally you've got a note sent out in advance from the inspector saying what they want to look at, and you also get a note following the conference saying what the inspector's decided. Now, the matters that can be decided at this stage are not set in stone, but the sort of key points will be what are the main issues in the case, but also parties should expect to inform each other of the number of witnesses they expect to be called in, who they are. Normally you should know that by this stage, and what they're going to cover. And from that you can start discussing what is the most appropriate timetable. Esther will no doubt talk you through the sort of the normal approach, which is for the council to present its case first, but you may think that in a particular case, a topic by topic approach is more appropriate, where you say, okay, let's deal with all of the evidence on highways first. So we'll hear the council, then we'll hear the appellant on highways, and then we'll move on to landscape and visual harm, for example, and deal with that. So this is the chance for parties to canvass their views on this. And it's also whether, it can be discussed whether particular parts of the evidence should be dealt with by matter of a round table, or not even by written representations where you don't need cross-examination on a particular point. So it can be very useful to flesh it all out, and it's also a chance for the inspector to hear if things have moved on, if at all, from previous stages, and if people have, if parties have not been meeting deadlines, which obviously won't happen, but if that is the case, it's also obviously a chance to set deadlines as well. So that is the case management conference, and I'm getting there. We next have the proofs of evidence stage, and this is 4 weeks before the inquiry. Proofs of evidence are essentially the written evidence that witnesses will speak to. So each witness will have a separate proof of evidence, and it's an opportunity to present your evidence to the inspector. You can obviously cover matters that have maybe been addressed elsewhere, but present it in a way that's useful to the inquiry, and provide professional opinions, particularly on the other side's case as you've seen it. I think this is littered with sort of secret top tips from experience, but I've put here: be concise, be to the point, but at the same time, don't assume the inspector, and this is really for your witnesses, but don't assume the inspector knows what's in your head. I think for some parties who've particularly been dealing with the bigger cases for some time, they may be very familiar with specific issues, but you do need to, it's sort of the same with any evidence, you want to hold the hand of the reader through your workings. So don't just give your conclusion, but explain how you got there, whilst not perhaps writing a full novel on it. These are some more do's and don'ts, and the one that I'm going to hammer home hugely, bugbear of, I think, not just myself, but many in the profession, is please, everything that is submitted to an inquiry, please make sure it has page numbers and paragraph numbers. That is an absolute must. Because once you get to the inquiry stage, you will find that your barrister will say to the witness during cross-examination, please can we turn to, and then say, oh, it's 25, I think it's Sarah, it's 25 pages from the end by the coloured tab, and it's a nightmare. So I think on behalf of everyone in the profession, and also PINs, please, everything you do, page number it at least, and also the more you can cross-reference documents and make it easy for the inspector to find what you're referring to, the better. So that's another sort of top tip. And I think the rest of it is probably pretty self-explanatory. The other one maybe to point out is that if you've got multiple witnesses, you may want to make sure you're not duplicating each other or overlapping too much. I'm just conscious of time, and I think I need to move on. So final steps before I hand back to Esther. This I think is a bit out of date in the fact that normally the council is in charge of arranging the venue, and they'll probably be giving you the details in normal times before COVID. But now, obviously, with a lot of it being remote, PINS is obviously sending out the links to the remote Microsoft Teams groups. So that should come from PINS. But certainly this is, it's worth noting that it's 10 days before the inquiry when you should be sending your draft planning obligation. So section 106, whether it's agreed with the other side or whether it's a unilateral undertaking. So that's to note there. And I think also to note, just before I hand over, generally speaking, there isn't provision for rebuttal proofs, which is where you've seen your proof and you want to say something more. Generally speaking, that's not provided for. And certainly the rule is no late evidence after proofs, really. But it does crop up, perhaps more regularly than you might expect, that the parties want to put in evidence late, especially at the inquiry, and what really it's supposed to be exceptional circumstances, but the inspector will want to know, if you're putting in late evidence, why it's late, what the relevance of it is to the inquiry, and also will want to hear from the other side, particularly on whether any prejudice will be caused from their side and whether they agree to it going in. So just to note that, but otherwise I'm going to hand over to Esther because I'm worried I'm running out of time.
Thanks, Mary. Well, that leads me quite neatly on to what I was going to say about what happens at the inquiry, because this slide sets out the sort of typical structure for an inquiry. But actually, I just wanted to emphasize that the procedure is at the inspector's discretion, and you really have to be flexible because anything can happen. It's very common for inquiry documents to come in on the morning when a particular witness is giving evidence. It's something you'll discuss as a team. The other side will be discussing it as a team with their barrister. If they've found some relevant document that they want to deal with with their witness or with the other side's witness, then those documents tend to come in throughout the inquiry, even though, as Merrow said, you're not supposed to put things in late. It should really all be going in with your proofs or your statement of case. And what I've set out here is also the sort of typical case-by-case approach, which was previously the norm, but now we're moving more and more to a topic-based approach, which Merrow also spoke about, where different reasons for refusal or the main issues are dealt with separately, and the witnesses for those topics, for first the counsel and then the appellant, will their evidence will be tested on those topics. That also enables the roundtable approach to be taken for discrete topics, which I will touch on in a moment. You might wonder what those abbreviations are. They're very common for barristers, but not necessarily for solicitors or planning consultants. So examination in chief, XIC, is the opportunity for you to explore, as a witness, for you to explore your evidence with your barrister. And I think I'll be talking in a little more detail on that in a moment. XX, cross-examination, is where the evidence will be tested by the barrister for the opposing side. So where a witness will be put under fire, hopefully, if we're doing our job correctly, and they'll have a chance to really defend their position. And then after XX, it's not on the slide, but there is an opportunity for then your barrister as a witness to go over your evidence again and deal with any points that you were challenged on, where it's felt you could give, you haven't given the full answer, or you need to qualify that answer. Your barrister has a chance to re-examine you as a witness. Merrow mentioned Rule 6 parties briefly. If they're giving evidence, they would normally then evidence would normally fit in after the counsel's evidence. So on a case-by-case approach, it'll be the counsel's whole case, then the Rule 6 party, then the appellant. On a topic-based approach, that would apply, but for each separate topic. And I just wanted to put in, for those of you who will act for appellants, a little word of warning about Rule 6 parties. I've acted for a number of Rule 6 parties, local residents, in inquiries, and just be prepared for the unexpected. Rule 6 parties have a lot of freedom that a local council doesn't have. They're not tied to the reasons for refusal. They're not kind of bound by what their members have said, or they can just put in some more unexpected arguments, and they might be a bit more bullish than a local planning authority might be. So don't underestimate them, especially if they're represented by council. Certainly when I've been involved with inquiries of Rule 6 parties, we've generally been pretty successful in supporting the council and kind of plugging the gaps where the council couldn't make a particular argument. And on the other hand, if you end up acting for a local council, then make use of the Rule 6 party and coordinate with them. And if the Rule 6 party is represented by a barrister, then there can be quite good co-working between your barrister and the Rule 6 party's barrister. So just something to be aware of. They're quite an unknown quantity in inquiries often. And I'd also just note that sometimes there is a slightly different timetable for enforcement inquiries if there's a legal ground in an enforcement inquiry. So for example, where there's an argument that the development is immune from enforcement action because it's been in place for 4 or 10 years, then the appellant will typically go first to make out their legal argument and then have a right of reply at the end. So if we go on to giving evidence, next slide, please. And Merrow has actually already dealt in detail with the proof of evidence. One thing I would just emphasize is coordination between witnesses. So if you are advising, if you're advising witness, or if you're a planning consultant who's drafting a proof of evidence, don't forget about the other witnesses in your team. Do coordinate your proofs with theirs, as well as avoiding overlap. You also want to make sure your arguments are consistent. It's the first thing that the barrister for the other side will do is try and pick apart any inconsistencies and sort of make ground on that. In terms of examination in chief, that's the opportunity for witnesses to make any revisions or updates to their proof. There might be corrections, mistakes they've mentioned. You could also respond to points made by the other side, your opportunity to give a kind of rebuttal to those points and expand on the proof. Cross-examination, really important to prepare thoroughly for this. Know all of your evidence, know the other side's evidence, know relevant parts of the evidence in other topic areas which might impinge on your area. And perhaps one of the most important points here is don't forget that you are there to assist the inspector. So however easy it is to get drawn into a kind of battle of wills with the barrister for the opposing side, do address your answers to the inspector, try and remain calm, as neutral as you can, and you'll be much more persuasive. So moving on to the next slide then, I think. Roundtable sessions. So as I said, it's increasingly common for these to be used, and you'll want to indicate your initial view as to which topics these should be used for in the statement of case, and also at the pre-inquiry meeting. Now, as I said, generally formal cross-examination, testing of evidence tends to work in appellant's favour. So you may want to tactically push for that rather than roundtable sessions. But it's also important to be prepared for roundtable sessions if you do end up having them. And if you're quite assertive and strong about them, you can actually sort of use them to your advantage, because it's actually a forum where it's quite easy, if you don't get the point in at the right point, to not have the roundtable will just move on, and then that point won't go into the inquiry. So if you're assertive, if you have an assertive barrister leading the roundtable, and you're also, as a witness, confident in your submissions, then you can actually almost take control of the roundtable. So if we go to the next slide, that's just a little bit more detail, kind of following on from what I said about preparation. Really, a roundtable and the effectiveness of a roundtable and inquiry will depend in large part on the inspector and how willing the inspector is to take charge, set an agenda, In my experience, sometimes the inspector will just say, well, I just want to hear short speeches from the main witnesses, and then ask them a few questions. And in that case, you need to be prepared to really present your whole case in that speech as sort of succinctly and persuasively as possible. So it's really important to kind of engage with what the inspector wants from the round table, and discuss with your barrister how best to prepare and how best to present your argument. But some ideas are on the slide there. And now I'm going to turn back to Merrow to deal with costs.
Oh, I'm on mute. Okay, and I just wanted to jump in as well, because Esther's presentations reminded me that we were going to just note at the beginning, but I forgot, that if Chambers does offer witness training as some of the services we can provide. So just to note that if that might be of use, we can do mock inquiries as well, which can be useful if you have witnesses who've never given evidence before and are just a bit nervous about the whole process. And also Esther's being very modest about the Rule 6 point. She's quite right. She's had a lot of success representing Rule 6 parties. Do not underestimate them. And I'll echo as well the fact that the acronyms for examination in chief and cross-examination, re-examination is RIX, are not as well known as I think the barristers think they are, because I certainly have had comments back from witnesses saying it looks like you're missing a document because I say so-and-so said this in XX, which means in cross-examination. So yeah, those are the acronyms that we use. Costs, right, so the starting point is each party to an inquiry bears their own costs. The exception to that rule is where you can say, well, one party has behaved unreasonably, and that because of the unreasonable behaviour, another party has incurred unnecessary or wasted costs. So it's a two-part test. You've got to show both that there's been unreasonable behaviour and that behaviour is what led to unnecessary costs. Sometimes it can be quite frustrating because you can certainly show unreasonable behaviour, but you might not be able to actually show that resulted in any additional costs that wouldn't have otherwise been incurred. So I just put that caveat there. It's noted here in the slide that it's really only in terms of the appeal process. It's not looking at your possible unreasonable behaviour during the application process, but the MPPG guidance on costs does nonetheless say parties' behaviour during the application process can be sort of considered in relation to cost applications. So take that as you will. I think that's a bit of a fudge. May be considered. So obviously you don't want to be acting unreasonably at any stage. Unreasonable is given its ordinary meaning. It can be an application for costs in part costs or full costs, and it can be made by any party against any party. And I would emphasize this, it can actually be a cost award can be made on the initiative of the inspector, even if no party is going after each other, if the inspector thinks there's been unreasonable behaviour. And you should make your application for costs as soon as possible. And if it's something that's arisen before you've got to inquiry, then really you should make that application for costs before you even get to the inquiry. But certainly before the inquiry closes, only in very exceptional circumstances would it be after. And you should really have always have the opportunity for the side against which you're claiming costs to respond to that cost application. The obvious sort of the sort of basic example is where we've talked about late evidence. It does happen quite regularly that parties put in late evidence, but where you've got one party sort of providing some new evidence or new information on the day one of the inquiry that really they could have provided at the proof of evidence stage or much before, and that requires either there to be an adjournment of the inquiry so the other side can consider the evidence, or perhaps the other side needs to call a different witness. Are you seeing this? This is coming up on the screen. No, okay. I just want to check you can't see my Adobe install thing that's coming up. No, but if your new evidence is it causes that kind of additional cost to be incurred, or it may be, on the other hand, causes an issue to fall away, which the party has already spent a lot of time preparing to deal with at the inquiry and has called witnesses to deal with, and now that issue has fallen away. These are the kinds of basic sort of standard examples where you'll be expecting a cost application for that. I think that's probably all I have to say on costs. So I think that takes us to our sort of, I'm going to hand back over to Esther for this. This is all to do with remote inquiries, which we're getting into.
So very briefly, keeping an eye on the time, this is our final slide, you'll be pleased to hear. And we just thought it would be useful to share some of our experience in this time of remote inquiries. They have become the new normal. PINS is mostly using Microsoft Teams in our experience, and they have also indicated that they're going to continue using remote software for some inquiries beyond lockdown. So it's something we all need to be comfortable with. So I've just put down some factors to consider there when you're preparing for the remote inquiry. Do you want to have all your team together in the room, or are you separate in your own homes, in your own offices? Obviously, space constraints for social distancing and communication in terms of using WhatsApp or something if you're not in the same room to take instructions and pass comments is really important. The venue, you need to consider if you're remote, what's your internet connection like? What's the background noise like? Will you have children coming into the room or pets or things? All of these things need to be ready in advance. What's the lighting like? What's your software like? Document sharing. So in inquiries, normally Merrow and I have been used to just handing up documents on the day of the inquiry, having core documents printed. How are they going to be made available to interested parties? How are you going to share them during the inquiry? Timings, virtual inquiries will take longer. Generally, people get screen fatigue. You need to have breaks, regular breaks. These all need to be borne in mind when you're considering the timetable, when you're considering time estimates, how long the inquiry take. And finally, is a blended approach appropriate? Will in future there be a need for inquiries to take place both in person and virtually? Are there particular witnesses or local residents who can't appear using their technology? That's something to consider. And I'll pass on to Merrow for top tips.
Yeah, and I would just echo what Esther said on the timings point. It's amazing how, I think there's been a lot of conversations about this, and certainly the inspectors are very aware of it. It's amazing how actually very tiring doing inquiries online are. In some ways you've got the home comforts, but something about doing testing evidence and doing things remotely, I think, can be quite draining. So they are very much aware of that, and trying to keep the inquiry days short and to have regular breaks. I've had some experience with a blended approach because I was involved in a rights of way inquiry that was very much at the start of lockdown, and where there was a lot of interest in the local community, and quite a lot of elderly residents were very interested who didn't have well, there were a lot of residents interested who didn't necessarily have very easy access to the online world. So we had a blended approach. I think we had a lot of learning points from it. And I think one issue is feedback loops where you have multiple people in the same room trying to access the same online portal. You need to be careful about who's got their microphones on and speakers on, and you can get feedback loops, which is quite tricky. But once you've worked out that only one of you should really have it on, I think that seemed to sort it out. And I'll probably move on to top tips now, just in light of time. I think a lot of this is self-explanatory. And I think what I would emphasize is keep this last point, keep checking whether your mic and video are on. There have, I'm sure you've seen in the news, there have been some terrible experiences of people with that problem, but I can not quite like that, but I can certainly say that from my experience I had in my last inquiry, my internet wasn't really good enough at home, so I moved to Chambers, and that day when I hadn't had a huge amount of sleep, I thought my camera was off while my learner friend on the other side was cross-examining my witness, and I just happened to do a very unattractive yawn and stretch, which I was caught out on, which actually provided some good humour on day 3 of a long inquiry. But do check it, and people have been caught out on actually saying things with their mics on during breaks. that the other side can hear. So obviously that's much more serious. I think the other top tip I would have, which has worked really well for the inquiries I've done remotely, is if you are all remote from each other in the team, work out a way that you can easily communicate with each other during breaks. These can be sometimes only 5 minutes long, and if you want to have a quick chat mid, examining the other side's witnesses, for example, you want to have an easy place you can jump to. So what I've been doing with my teams is having, Esther says normally pins is Microsoft Teams, having a different platform, for example Zoom, where you've got an on all day Zoom sort of session in the background that you can always log back on and off. And if it's a break, you can all log on and have a quick chat and log off. Just make sure your mics are off in the right ones at the right time. But that has actually worked pretty well. The other point is obviously to just be aware that normally in inquiries, certainly as us barristers, you'll be sitting with your team and you can take instructions very easily. People can hand you notes and tap you on the shoulder. It's not as easy, but as you say, you can have emails coming through and all the rest of it. But I think it's worth noting that it's always open to say to the inspector, can we take a very, very short 5-minute break for me to check with my team, and give an opportunity to the team to just check that nothing's been missed, for example. I think that's quite important to be aware of. I think that's probably all I have to say on that. So unless there's anything else, Esther, I'm going to move to this slide, which is, we hope, really useful. So reiterating what I said before, these are your tickets to learn more. And we've also got this YouTube video, which I think is designed for interested parties, but is certainly a good intro. And I think this also from Pinson's is about specifically virtual planning inquiries, which, as Esther says, is the new normal. So I think that wraps us up quite nicely on time. Yeah. And we now have questions. I'm going to see if I can unshare my screen because that will allow me to maybe stop share. That's it. I think now I can see the chat box.
Yeah, I don't think we have any questions. So unless anyone has anything burning to ask.
Right.
Might leave it there.
Now's your chance. Now's your chance. But if not, obviously, we hope it's been useful.
And there are lots of links and things to follow up in our presentation, which will be circulated. So hopefully that will.
Oh, okay. We'll just have a thank you. Thank you. We'll be on here for just a minute more. And if any of you have any questions, please do. Otherwise, wish you a very happy Wednesday morning in February during lockdown. As happy as it can be.